Hello and welcome to May's webinar, where we are discussing two topical issues which are often interwoven by the work that we do here at Doyle Clayton and the clients who we support. And those two issues are focusing on financial conduct rules and non-financial misconduct rules, and also changes that we are seeing coming in October of this year with regards to the preventative duty around sexual harassment, and also around harassment and third-party harassment as well. So I'm not flying solo today. I am thrilled to be joined by two of my fellow partners. Firstly, Kate Kapp. Kate is an employment partner and head of our Thames Valley office. And Kate, fantastic you can join me today. Welcome.
Thanks, Emma. Great to be here.
And I'm joined also by our new regulatory partner, Benedicte Perowne. And Benedicte, fantastic to have you here.
Thank you very much, Emma.
And Benedicte's going to be kicking us off in a moment, talking about those regulatory changes, which are incredibly important. But before we start, we get lots of people finding Webinar Wednesday, and it's really good just to share who we are and what we do and who we do it for. So Doyle Clayton is a specialist workplace law firm. We have offices in the city, in the Thames Valley, and also in Bristol, and we support clients across the UK, across Europe, and also globally as well. And we do that through employment and HR support, litigation support, whether that's in the employment tribunal and the appeal courts, but also in the High Court with High Court litigation. We also support clients with training, regulatory advice, investigations, so advising on or undertaking those specialist workplace investigations. We also support clients with immigration advice, as well as corporate support and EOT. So lots of ways in which we help clients. So again, please do get in touch with me if I can give you some more information about the firm and how we can support your business. The London Masterclass happened a week or so ago. Absolutely brilliant, fantastic delegates came. We had lots of lively discussion, lots of questions around the whole employee life cycle. So if you would like to come and join the Masterclass 2026, then please do sign up. We've got a session running in our Thames Valley office and our Reading office on the 3rd of June. And also for those of you who are in the Southwest, and I know we get lots and lots of you joining from Bristol and the surrounds. So again, please do come and join me on the 10th of June in our Bristol office. The course is aimed at HR professionals at all levels, but primarily those who are perhaps starting their career, mid-level professionals, or maybe are returning after a period of family leave, just want a refresher. We'll be focusing on, as I said, the whole employee life cycle, and it really is a mix of employment law, but also HR best practice. So again, I'll be sending out details of how you can sign up to that. Always looking ahead, as you know, here at Doyle Clayton and Webinar Wednesday, and June's webinar, we are talking about dismissing employees, not just with an eye on what is coming down the track in 2027, but also looking at it from a comms perspective as well. How can we support those individuals who may be leaving the business, but also more importantly, how can we look after those who are staying from a comms and engagement perspective? So again, watch out for invites to come and join us for that webinar. And if that wasn't enough, please do listen to our DC Talks podcast. It's a 25-minute chat about all things legal, HR, leadership. And this month's podcast is all about AI and the use of AI by HR teams, but also what may or may not be going on in your workplaces and what HR need to do to stay ahead and get on top when it comes to AI. So again, you can find us there at all the usual podcast places. Bit of housekeeping. As you know, this is a webinar and we are not giving advice. It is a high-level discussion, really to give you a heads up on both the regulatory things that you need to be focusing on, particularly around the financial sector, and also around sexual harassment and preventative changes. So again, if we can help with business-related queries, then you know how to get in touch with us. So let's start the conversation. And Benedicte, let me bring you in to chat about really what's going on in the world of regulatory, financial regulatory, what's happening in terms of changes and what businesses can do. So if you can just start off just by explaining a little bit about financial misconduct and obviously non-financial misconduct as well. Where has all these changes come from?
Thank you very much, Emma. I'm just going to start at the beginning, really. So following the financial crisis in 2008, 2009, financial regulation in the UK was split into two organisations. So you now have the prudential regulator, the PRA, and the conduct regulator, the FCA. So obviously prudential is the commercial soundness of the firm. Do they have appropriate systems and controls in place to manage the risks, and do they have those systems which will look at the financial resources to deal with the business? So it's sort of, you can think of it of the firm and its sort of wider surroundings, so the firm in sort of the sector that it's in. And then you have the conduct regulator, and conduct is effectively how firms carry out their own businesses and treat their own customers. So it's a more sort of the firm and how it is operating. So in the UK, many of the large organisations are regulated by both the PRA and the FCA, but a lot of smaller organisations are what is called solo regulated, and they are only regulated by the Financial Conduct Authority. But either way, we're in a situation now where there have been a number of things that have been said by both the regulators over time in relation to what is called non-financial misconduct, and also originally in relation to D&I. And both regulators put out a number of sort of discussion papers, consultations. Largely now, the prudential regulator is leaving these sort of matters to the Financial Conduct Authority, primarily because, as it says on the tin, it's the conduct regulator. So that's the regulator that is concerned with sort of what's going on.
So just to sort of explain, I suppose when we talk about financial regulators, are we talking about banks, or are we talking about kind of financial institutions, maybe in a wider sense?
Yeah, thanks, Emma. It's a really good question. And we're really talking about any organisation in this country that is involved in some way in financial affairs in their business. So obviously, there are the big, huge banks that we all know about, and they are dual regulated, and they will have very close involvement by the financial regulators in their businesses. But at the opposite end of the spectrum, there are organisations who will just do a few financial related matters as part of their business. So they may not be squarely within the financial regulated sector, but they may have particular licenses or particular elements of registration with the financial regulators. And what I'm going to talk about here will be relevant to their businesses, even just in sort of a small way, or even just by virtue of the fact that they are operating in this sector. And I'm talking here about financial regulation, but actually a lot of what I'm going to talk about when we're thinking of conduct and culture, it is relevant to people, firms and organisations and people in other regulated sectors as well.
Fantastic. So non-financial misconduct.
So as I said, we're thinking here about the FCA as a conduct regulator, including how through the behaviour of the firms and the individuals that they regulate, they maintain the trust and in the integrity of the markets. And that's one of the aims of the FCA. So as long ago as 2018, the FCA was saying that they recognise that cultural failings in financial services firms had been accepted as a sort of key root cause of some of the big failings in the industry in recent history. And that's actually not just for financially regulated organisations. Actually, there are a lot of sectors where you see huge conduct failings as causing sort of issues in wider society. And we can all think of things that have happened over the last probably 10 years that have caused changes in society, things like Me Too, Black Lives Matter, these big movements that have come about because of what is now labelled non-financial misconduct. So the regulators have said repeatedly, and although they're only making rules now, they have put out speeches, they've put out papers saying that they expect firms to foster healthy cultures. which support the spirit of regulation in preventing harm to consumers and markets. And this concept of the spirit of regulation is really important. I'll get on to some of the rules, but actually for regulated firms, and not just financially regulated firms, this expectation by regulators that firms recognise the spirit, recognise actually what we're all trying to achieve here. You don't need to actually get very bogged down in the rules. You just need to recognise that we're all trying to achieve a good environment to operate in. So it has been nearly 10 years since the financial regulators started saying that they viewed non-financial misconduct the same as any other sort of market misconduct, and that therefore, from their perspective, it would be relevant to the assessment of that firm and to individuals in the same way as a firm's handling as any other sort of market misconduct. So, for example, insider dealing, market manipulation, they would now start to treat all of this in the same sort of way. So now firms really do need to appreciate, and as I say, although the financial regulators are going first, it's not just those in the financial regulated sort of sector. Culture and individual accountability are really, really live supervisory risks that firms really need to pay attention to. Non-financial misconduct is squarely within the FCA's regulatory perimeter, really already, and there have been what are called final notices that show that actually this sort of misconduct is relevant to decisions that the FCA is making about firms. The regulators use it really as an indicator of culture and governance quality, and of a test as well as those at a senior level within firms can effectively be trusted with the management of those firms, and to deal with that behaviour before it causes harm that reaches either the customers or the markets.
Let's have a think now, shall we, about what those conduct rules are.
Yeah. So as I've sort of said, it's taken quite a long time to kind of come to fruition, but we're here now, and there are rule changes that are coming in place on the 1st of September 2026. And as I say, that date is a date that's really, really key and will be front of mind for those in the financially regulated sector. But it is actually also an opportunity for other firms to kind of think about, well, how are we dealing with these sort of behaviours within our organisation? So from the 1st of September, there will be a new conduct rule. And the conduct rules, I mean, they're broadly firms that fall within what is called the senior managers regime. These conduct rules are broadly applicable to all employees within those organisations. Now, at the moment, the conduct rules apply in a slightly different way to what are called banks and non-banks. And there will be other firms within the regulated sector that actually the conduct rules don't apply really at the moment at all. So, for example, appointed representatives, and I know there are a few on the call who do fall within the appointed representatives regime. That said, that regime may be changing, and the senior managers regime is going to be changing. So we don't know where things are going to end up. And in any event, if you step back and think back to what the financial regulators say, it's about the spirit of regulation and not just specific rules. I would say that an organisation to who the conduct rules don't apply actually can't just completely ignore what those rules require, because they're requiring individuals to act with honesty, to act with integrity, to act in the best interest of customers. And that's the sort of behaviour that anyone would expect of their organisation in any event. Broadly, these conduct rule changes and everything that the regulators have said are making it very, very clear that conduct which will not be acceptable includes conduct that has the purpose or effect of violating an individual's dignity, of creating an intimidating, hostile, degrading, humiliating, or offensive environment, conduct that is violent, and the regulators provide a number of examples of these. In relation to the conduct rules, the regulators make clear that it's conduct within the workplace. So, for example, an individual who is commuting to their place of work and behaves in a particular way, that behaviour would not fall within these conduct rules. And conduct that takes place in an individual's private life is also not relevant to the conduct rules. That said, organisations for whom the conduct rules are relevant and where the senior manager's conduct rule kicks in, there is a rule there that requires the senior managers to tell a regulator of anything of which the regulator would expect notice. Now, if they're performing in a particular way in their private life, although it may not fall within the conduct rules because of what I've just said, actually the regulator would expect notice of that. So there are nuances to these, and firms really, really need to take time to understand these nuances, how they apply to their organisations, and most importantly, that their individuals within their firms really understand the consequences of these rule changes.
That's really interesting, particularly the language there that the regulators are using. And Kate and I, our ears will prick up when we hear the kind of the language around creating offensive environments. We see that, don't we, when we talk about harassment as well. And really wide expectations there, aren't there, Benedicte? You were saying about the reporting expectations. That's going to be a really tough call for an organisation to make, particularly around the is it conduct within the workplace and conduct in one's private life? And again, we see lots of cases that arrive in an employment context, but it's is it conduct in the course of employment? And Kate and I can touch upon that later. Fitness and propriety, these are words that come up a lot, don't they, when we talk about non-financial misconduct. So just talk us through what we mean here.
Thanks, Emma. Yeah, so the changes that the regulator are bringing in, as I've talked about the conduct rules, but there are also changes that are coming in relation to fitness and propriety. And this is, the regulator has effectively tried to provide additional rules and guidance to give firms better clarity on where conduct that has occurred is relevant to an assessment of fitness and propriety or not. And some of this guidance has come off the back of big findings that the regulator has made in relation to quite extreme examples of misconduct. So where there's either been very physical violence or, as I say, fairly extreme and horrible and horrific crimes that have been committed. And in those sort of situations, of course, you would expect that to be relevant to a fitness and propriety assessment, where somebody has ended up in prison for whatever extreme offence it may be. This further guidance is showing firms that actually what they really do need to consider when they're thinking about behaviours that have arisen. And in this case, we are looking at not just behaviour in the workplace, we're also looking at behaviour outside of the workplace. So that example I gave about commuting, that would be relevant to a fitness and propriety assessment. The other thing to think about fitness and propriety is it is much more it's much broader. And so, for example, appointed representatives, there is a fitness and propriety assessment that needs to happen for those firms in a way that conduct rules do not apply. So a lot of the guidance that is given is around how far do firms need to investigate? Do they need to consider every allegation that is raised against an individual? So, for example, if there is an allegation which, even if it were true, it would not be relevant to an assessment of fitness and propriety, then is that something that they really need to worry about? But as I say, the FCA does emphasise that misconduct in a person's private life may call into question their integrity, their judgment, or the reputation if it shows that there's a material risk that the individual will breach regulatory standards and requirements. So that's the key term that the financial regulator is using here, material risk. Examples that are provided, as I've already mentioned, the commuting one, but misconduct towards another member of the workforce, but while they're at a social gathering, organised sort of separately in a personal capacity. The FCA have said, and it's quite helpful that they give this confirmation, that it should not be assumed that simply because a member of staff that is being assessed as fit and proper engages in conduct in their private life, there will be a material risk that they will repeat such conduct in their regulated role. So if there's a remote or a speculative risk that the member of staff that's being assessed will breach the standards, that's not sufficient. And they also have said that they want to ensure that behaviour that undermines the market confidence or workplace safety is appropriately considered. but it's not their place to police personal morality or enforce investigations just because the behaviour feels a little bit uncomfortable.
And I think, taking all of that into account, there are things that businesses need to do. Time is tight, the 1st of September. So, Benedicte, what should businesses be thinking about?
Yeah, and I mean, as Emma said, there's a lot going on here, and there's a huge amount of guidance, and it can be quite difficult to navigate it and actually to work out how it's relevant to a firm and how it's relevant to the individuals within a firm. So firms should be using this opportunity now before the 1st of September to really take stock of their entire compliance framework with regards to non-financial misconduct. And obviously, don't want to do that in a silo. And obviously, Emma, you'll come on and Kate will come on to talk about the employment law angles and changes that are also coming in. As I say, you don't want to do all of this and all of this kind of consideration on one side and not on the other side. So it's thinking about the sort of entire compliance framework. And really thinking about the extent to which enhancements can be made. Firms have a duty to notify staff about the changes and take all reasonable steps to ensure that their staff understand how to apply them. And also, as I say, there's a kind of a different level. So there's an employees level, but there's also a more senior level. So do senior managers know what their responsibilities are as distinct from the individuals? And then those who are going to be applying these rules and considering particular behaviours and misdemeanours, do they really know and understand how to interpret these rules? But this is absolutely not just a training thing. That's kind of one small part of it. So it may be that I want to review internal policies and procedures, conduct a gap analysis to understand actually where are the issues that we're going to come up against. Is there any appropriate guidance on appropriate conduct and what that will look like? And do you want to do any updates to employee handbooks? As I say, is there any guidance to those who will be managing particular instances of non-financial misconduct? Can the managers apply these rules? Do they know how to demonstrate the standards? The regulators will want to understand and expect firms to be able to demonstrate what steps firms have taken in order to implement these changes. And firms need to make these nuanced judgment calls about conduct that's happened at a drinks party in someone's garden on a Sunday where it's a whole load of employees there together. So as I say, there is a lot going on. There's a lot of different levels of people to consider, and the reviews of policies and things goes quite wide in terms of thinking about which policies and guidance within a firm may be relevant.
Thank you very much. And I do think, this synergy between September changes around conduct and obviously the changes that are coming in the employment world in October, there is, and as I've been saying, in all of these times of challenge comes opportunity actually to rethink and revisit. But be very afraid. Benedicte, is it safe to get back in the water?
Yes, and I mean, absolutely. And I think what everyone needs to think about, all of these changes that are coming in at this time are really sort of responding, as I said at the beginning, to sort of events and issues and things that have arisen sort of broadly in society. Obviously, the financial regulators have set all of this out. They are not the only regulators, though, to be making noises in this area. The SRA, for example, published a paper a couple of years ago on sexual harassment and how to deal with that within a workplace. So I would say, obviously, those in the financial regulated sector almost have sort of got their rules now. They know sort of where they need to head on this. But those in other regulated sectors, actually, it's an opportunity for them as well to really consider, well, actually, are we behaving in such a way that sort of makes us proud? And are we doing things well? So although these rules are not sort of specific to you necessarily, actually, it's an opportunity to really consider kind of, well, what is our culture? What role do our senior leaders play? What role should they play? How are we demonstrating good culture within our organisations?
Absolutely, and sound advice there. It is an opportunity to really think about getting your, as you say, getting your house in order and making sure that we are doing the things that we want to do as an organisation. And I think, one of the key areas and the key focuses of behaviour is obviously the Equality Act. And, giving a sort of an overview in terms of what the Equality Act is, it's a framework, it's a behavioural framework which sets out protected characteristics and also protected behaviours. And as we know, that covers obviously discriminatory behaviour, so less favourable treatment of somebody who has a protected characteristic. But remember, it's wider, isn't it? The Equality Act has a huge scope and impact on employers and also businesses at large as well. It's not just the protected characteristic. We have associative discrimination and discrimination by perception as well. So indirect, direct discrimination. And then we have harassment. So again, mirroring some of the language that we heard Benedicte talk about in a regulatory context there, this, unwanted conduct, related to a protected characteristic. And again, looking at the impact of that in terms of the working environment, creating this hostile environment for the individual. And again, really focusing on where that conduct has taken place in the course of employment, which, as you will know, if you've joined one of my training sessions, you'll know that concept is incredibly wide now. Sexual harassment. Again, it's one of my top training topics at the moment. Again, talking to HR teams, managers, senior leadership teams, as well as employee populations about unwanted conduct of a sexual nature. And again, what that means and what that looks like within the workplace. And another really important area, which is sometimes overlooked, another really key risk point in the Equality Act, is looking at victimisation. So, retaliatory behaviours, where somebody has raised or supported a claim or an allegation of discrimination within the workplace. So the Equality Act's net is wide. It applies not just to current workers, it applies before somebody has joined you. So it can, we see claims often that arise during the recruitment process, as well as oftentimes when an employee has left you. So the net is very wide. And Kate, I'm going to bring you in now, because the topic of this webinar is obviously looking at the costs. And Benedicte's talked about the costs for those of you who are in the financial regulated sector. But let's really think now about the costs more widely and the cases that you deal with and the clients that you support. Kate, what are some of the costs and the hidden costs as well of such claims?
Thanks, Emma. And yeah, I think this is really important, because the costs of getting this wrong are very real. And I think they're much wider than probably most organisations anticipate. So firstly, of course, we have litigation. That is costly and complicated. We are definitely seeing a steady increase in discrimination and harassment litigation, probably thanks to the ever helpful ChatGPT as well, assisting individuals in understanding their legal rights and exactly how to pursue them. But even where we have some litigation and we ultimately end up defending that claim, the management time being involved in the disclosure of evidence, taking witness statements, is considerable and really distracts from business as usual. So a huge time cost there in relation to litigation too. Compensation is uncapped in discrimination and harassment claims. So we see relatively large injury to feelings awards happening in those sorts of claims, but also sometimes quite large personal injury awards as well. But the bulk of the compensation usually arises from financial losses. So in cases, especially where individuals have suffered a personal injury and are unable to work for some time, financial losses can be quite considerable. So there's no sort of nice cap on that compensation. You often just don't know what your exposure is at the outset of a claim. We've also got the impact on people, and of course there is the obvious damage to the victim, but there can also be quite significant impact on the alleged perpetrator. And I've seen that quite a lot in the cases that I've been involved in. And often HR teams are heavily focused on supporting the victim, which is understandable, but also during these internal processes, should actually also be provided to the alleged perpetrator, who is often going through quite a difficult time as well. You may also get employees going off sick during this time as well. So the impact on people can be quite significant. Next up on the slide, reputational damage, and I really can't stress this one enough. Even where a claim is defended, those involved, particularly in harassment claims, suffer personal reputational damage. If you get all the way to a final hearing, the judgment is going to be online. Sometimes you get reporters turning up to the employment tribunals, and certainly some of my clients have experienced this. So there is a real risk to personal reputation that can exist for quite some time. Also, of course, there'll be considerations to employer brand and culture, team dynamics, the reputation of senior individuals involved, and really thinking about the wider trust of staff in leadership, because once there is this reputational damage, it really does sort of ripple through the organisation. Next up, work environment, culture, and engagement. So from my experience, Emma, you've probably seen it too, even one badly handled complaint can ripple across an entire team or sometimes across an entire organisation. You see productivity dropping, absences increasing, you might see some knock-on grievances happening as a result of that complaint. And a negative perception of culture within an organisation also has a significant impact on retention and recruitment as well. Personal liability. So individuals can be named personally in Equality Act claims, and we see this happening more and more now, often as a negotiating tactic. And in fact, ChatGPT will tell an individual to name personal individuals. So this can be very concerning and distracting for individuals that are named within litigation. They are personally and severally liable for any awards that are made as well. So that can be quite concerning too. And of course, an employee does not need to have left employment to raise a concern. These issues can and do surface mid-employment, and that leads us sort of quite nicely on to the last point on the slide here, which is the victimisation risk. And we're deliberately stressing this victimisation risk today because it's often where employers find themselves actually with a second legal issue while still trying to deal with the first one. And Emma mentioned victimisation earlier. It is essentially a retaliation risk. So if somebody raises, supports, or is suspected of raising a complaint of discrimination or harassment, and they're subjected to some negative detrimental treatment, that can become a standalone claim for victimisation. So in practice, victimisation can be quite subtle. So somebody has made an allegation or raised a claim and they're sidelined. They have a training opportunity withdrawn, or there's a sudden change in tone in the way that they're managed, or they're excluded from a project or perhaps from some work social events. So even where the original harassment allegation is contested and it's argued that there was no unwanted conduct, poor handling afterwards or some of this sort of subtle detrimental treatment can create a strong victimisation case for somebody. And where employees remain in employment, this risk is much higher. And I've actually seen it happen where managers have been accused of some sort of discriminatory decision, and they're almost trying to protect themselves by having nothing to do with the employee because they're worried and concerned about anything that they might say, and just distancing themselves from that employee creates that detrimental treatment, creates that victimisation risk.
I think if anybody is struggling to persuade senior leaders or finance to invest in legal training on the Equality Act risks, the personal liability point is always one to flag, and certainly the issues raised on this slide. So please do let Kate and I know, and we can share those with you. But it's not just Equality Act claims as well. The knock-on effect of such behaviours in the workplace can bring other issues as well, Kate, as we've got on the slide here.
Yeah, absolutely. So conduct and disciplinary issues, of course, bullying or inappropriate behaviour often becomes a disciplinary matter. Um, and if you get that process wrong in any way, then you risk an unfair dismissal claim potentially, or at the very least, a lengthy appeal, both of which are going to take up a significant amount of HR and management time. You often and regularly see an increase in grievances and complaints. And these escalate risk anyway, not necessarily because of the subject matter of the grievance or the complaint, but they can lead to other issues, especially where we start seeing sort of delays happening, or sometimes confidentiality breaches and allegations of lack of independence in relation to the people that are investigating those complaints. So that can sort of move on into other legal complaints, including the next one on the slide here, constructive unfair dismissal. So this is where an employee says, the failure to protect me from perhaps the bullying or the discrimination or the poor handling of my complaint has destroyed my trust and confidence in my employer. And so I had no choice but to resign and consider myself to be constructively unfairly dismissed. And even in a situation sometimes where an employer thinks it's been quite pragmatic in dealing with these complaints, the employee experience can look quite different. And if somebody can establish that the trust and confidence has been broken, they might succeed in that sort of a claim. We've also got civil claims and penalties up here on the slide. So claims linked to workplace harm can go sometimes beyond the tribunal framework, depending on the facts of the case. So this can include civil claims of harassment in some circumstances. And finally, those personal injury claims that I mentioned earlier. So in some cases where somebody has been bullied or harassed, they suffer perhaps a stress-related illness as a result of the treatment they were subjected to. Again, this raises the stakes in terms of risk and time spent in terms of preparing a defence in relation to a personal injury claim, the evidence in that claim, and obviously the increased compensation that's linked to it. So I think overall, employers need to treat these issues as multi-risk events. They're not single HR processes. I think the legal lens shifts quite quickly depending on what's been alleged and how you respond and what happens to the individual afterwards. So there's a lot to think about.
And sometimes we can see criminal, allegations being raised as well. So you've got that dual criminal investigation there in terms of individual behaviour, but then the workplace then having to investigate to support the individual concerned. So as you absolutely said, it is multi-faceted. And then we throw in the non-financial misconduct as well. So often interwoven. And just to sort of raise as well, whistleblowing, we know that from April, allegations of sexual harassment at work again became a standalone potential. They're protected disclosure. So again, watch out for that. Update your policies, and obviously your whistleblowing champions need to know about that. And also we've got some changes that we expect to see next year, Employment Rights Act related with regards to NDAs and what may or may not be allowed to be put in settlement agreements or NDAs with regards to trying to prevent the disclosure there of any harassing, discriminatory or sexually harassing behaviours. So that one is one to watch, and there's consultation out at the moment if anybody is interested in getting involved and having their say. So let's take a bit of a deeper dive, Kate, into sexual harassment and unwanted conduct of a sexual nature. And let's really think now about the preventative duty, what it is, what it means, what employers should be doing now, and with a look forward in terms of October 2026, and then some sort of tips on what we can, how we can support. So let's just give a little bit of a recap in terms of the duty there, the preventative duty from 2024.
Yeah, sure. So the preventative duty that came in October 2024 is a mandatory, positive, proactive duty on employers to take steps to prevent sexual harassment in the workplace. The key shift here was that you cannot wait until there's been a claim or there's been a complaint. Prevention has to happen in advance. So you're thinking about risk and controls before any harm actually occurs. So right now, the language in the legislation is that employers need to take reasonable steps. But as flagged on this slide, from October 2026, the bar is going to rise for employers to have a duty to take all reasonable steps. And this might sound like semantics, but it actually really matters. All reasonable steps invites a harder question from tribunals and from regulators. And they're going to be asking the questions, what did you do? What else could you reasonably have done? And if you didn't do that, why did you not do it? And they're really going to be taking a deep dive into this. So it is an important change coming up in the next few months. It's also a good opportunity to remind employers about the third-party risk changes that are happening as well. So also from October 2026, employers are going to be required to take all reasonable steps to prevent harassment by customers, by clients, by contractors, visitors, members of the public. So this is going to also apply to all types of harassment, not just sexual harassment. So we've got a substantial expansion on employer liability happening here. And of course, what's reasonable will depend on size, sector, workforce makeup, working environment. And the Equality and Human Rights Commission has set out some guidance. It's not a one-size-fits-all approach. So a small professional services firm and a national hospitality business won't evidence compliance in the same way, but both must be able to show that they've thought about the risks and taken proportionate steps in relation to those risks. And then finally, there on the slide, we have got some compensation consequences for getting it wrong. So if an employer fails to meet the duty, compensation awarded in respect of sexual harassment claims can be uplifted by up to 25%.
Yeah, absolutely. It's not a standalone claim, nor does it become so when we get to October. So the raising of the bar, but as we know, it's not just the employment tribunal or the regulators that we need to be concerned with. As you mentioned there, the Equality and Human Rights Commission, great guidance there, some useful tools on their website, but also they are an organisation that has teeth as well, aren't they, Kate?
They absolutely are. They've been given quite wide powers in terms of their enforcement, actually. And that will include, the ability to come in and investigate potential breaches that are reported to them, to serve notices requiring employers to prepare an action plan, to remedy any breaches and prevent future breaches, to require employers to enter into legally binding agreements, to take certain steps to address issues of discrimination or harassment, or even to seek injunctions against an employer to restrain it from committing an unlawful act.
Yeah, not to be underestimated. And we've seen recently some interesting binding agreements that have been made, with some really big retailers in particular, so worth having a look at those. So, as you said, Kate, it is a positive and proactive duty. We can't wait for complaints to be made. And I think there is this real shift in cultural language from well, of course, this won't happen here, to actually, well, it could happen here. And what steps can we take, reasonable and all reasonable? And I think you would agree with me that the risk assessment is really the key to understanding one's reasonable steps and all reasonable steps.
Definitely. That's absolutely your first starting point. If you haven't assessed risk, it is going to be very difficult to prove that you took reasonable steps, let alone all reasonable steps from October 2026. And a good risk assessment is not a generic template. You really need to tailor it to your specific business, how your people actually work, where any power imbalances sit, where you're aware that some boundary testing behavior might arise, where reporting isn't being carried out, where does it feel a little bit hard. And the best thing you can do is use some of the data that you already have. So we talk about on here previous complaints and exit interview data. I think that's really crucial. Patterns often show up in this sort of data. You might have received repeat informal concerns, repeat sickness absence within a team, turnover hotspots, or, particularly in certain places in the business. So the preventative duty really does expect you to learn from what you already know, and that's data you already have. So using it is key. Pay attention to your social events and your grey areas. That includes conferences, client entertainment, work parties, away days, even WhatsApp groups that are connected to work. The risk tends to arise where the formality drops, and also where alcohol is present. We definitely see high risk in those areas. So take a review of those sorts of events that you've got going on. Think about your policies and your processes and updating them. Many organisations have historically relied on a short harassment section within their staff handbook, but the direction of travel is now definitely towards a much clearer, accessible, standalone policy, setting out the behaviour that's unacceptable, how to report it, what happens next, and how confidentiality and protection from retaliation will be dealt with within an organisation. Training is key. As Benedicte said earlier, it's just one of the things that you need to do. It's not the only thing, but training is definitely very key. But it needs to be meaningful and it needs to be refreshed. It's not a tick box exercise. You should have different content for your staff, for your managers, and for your senior leaders. There should be scenario-based discussion in there relevant to your particular environment, and periodic refreshers that really reflect real risk areas and the lessons that have been learned over the course of the following year. You should be reviewing your complaint procedures and your investigation, the way you investigate. This is often where employers fall down. Spoke earlier about delays, lack of independence, perhaps unclear terms of reference when carrying out an investigation, not thoroughly investigating all of the allegations, poor communications to the parties, or perhaps inadequate protection and support measures while those processes are going on. So how you deal with complaints, how you investigate, what your processes and procedures are, that should definitely be reviewed. Think about your workplace culture, and that's not just a fluffy thing. Culture shows up in whether people believe they're being taken seriously, whether they believe that complaints that are being raised are being dealt with robustly and taken seriously by an organisation, whether managers challenge, banter, and inappropriate behaviour, whether senior people are held to the same standards as others. So they're all important things to reflect on when you think about the culture within your organisation. And then third-party risk, liability risk, as I mentioned earlier. Now's the time to be thinking about your client and your customer-facing roles, any lone working, any travel, any environment where somebody external has access to your staff. And practical steps here can really include reviewing your contractual arrangements with your suppliers. What are your reporting routes for third-party incidents? Does your training include your staff understanding and how to deal with a third-party incident, how to report it, and making it clear that leadership will be supporting them to enforce those boundaries?
Absolutely. I'd really reinforce the bit about culture there around your staff having faith in your policies and your processes, and ensuring that you are, as transparent and open as you can be. That really does make a difference. So as I've said, in all challenge comes opportunity, and I think there's a real opportunity when we think about the changes that are coming in with the Employment Rights Act from October, but also the changes that Benedicte's been discussing around non-financial misconduct from the 1st of September. Lots to do, yes, but again, where are those opportunities? And Kate, I'll come to you first in terms of where do you see HR teams should be focusing their attention on between now and obviously October?
Well, I think if you haven't focused your attention on a risk assessment yet, that is key and a place to start. So start collating that data that you've already got. Look at refreshing your policies and procedures. You need to make sure that they're working, to meet these changes, but also to suit the needs of the organisation. Think about how your messages are cascaded down from leadership to the employee population. Really think about your training. As I mentioned earlier, different training for different audiences, depending on their obligations to help you meet your duty. Thinking about those third-party risks, and whether you need to start looking at the contractual relationships that you've got with suppliers, and whether those contracts need to be changed in any way. And just thinking about culture and behaviours generally. How open is the culture about discussing issues, raising complaints? I mean, we do hear clients say time and time again, we don't have those sorts of complaints raised here. That's not always a good thing. Sometimes that can mean that you've got a problem and that people don't feel that they're going to be taken seriously. They don't feel that they're going to be supported. So it is really important not to just sort of put your fingers in your ears and pretend it's not happening.
Yeah, Benedicte, I can see you nodding there around, the advice really, not just for HR teams, but obviously from compliance leads as well within organisations. What issues should they be thinking about?
Yeah, well, I mean, I think it's really an extension of everything that Kate has already said. And I guess for the compliance leads, and I talked about it, Kate's already talked about it, it's really thinking about all those individuals at the different levels and really making sure that everything that you're doing is both bespoke to your organisation, the strategy that you're trying to achieve as a firm. So really thinking about it from that perspective and not just doing some sort of very standard training program that doesn't really go into very specific to your strategy, to your firm, those specific examples, those specific case studies. But then also those individuals at the different levels. So at the more junior levels, at the more senior levels. At the more senior levels, is it the obligations that apply to them that may be applicable because they are at a more senior level, but also supporting those decision makers and those people with that responsibility who are going to need to deal with these tough issues that they need to consider.
Perfect. And how can we help, Kate, Benedicte? How are we helping other clients?
Well, definitely with policy reviews. Benedicte and I have been doing policy reviews in conjunction with each other, just to, ensure that policies are fit for the new duty and usable in practice. That training, including, in relation to the regulatory context, and the preventative duties, we run a lot of that training too. Benedicte, I suspect you'll agree in relation to sort of the strategic planning. We talked about the compliance strategies, especially where HR and compliance functions need to align on a lot of these issues. We can absolutely help with those. And those risk assessments, we can help you make sure that you've really drilled down and thought about the risk exposure in your particular organisation. And we can help review that existing data that you have in relation to exit interviews and previous complaints to try and help you identify where your risk areas are, what you're already trying to do to mitigate that risk, but what more you might be able to do to satisfy the all reasonable steps that are coming in October. We also, of course, have a specialist workplace investigation team here who can come in and carry out independent investigations, support with thorough, robust investigation reports that can help the investigation have some integrity, and especially in a regulated environment, that can be really helpful when you're trying to show external stakeholders how seriously you deal with these sorts of issues, and that there's integrity behind the outcome to it. And we, of course, can provide litigation advice and support where that's needed.
Absolutely. And, particularly that strategic planning, doing lots of that at the moment, helping clients, particularly with, planning, risk assessments, etc. So lots of help and support that we can give there. And of course, if you want to get in touch, I will be sending out an email after this. So please do get in touch with us if we can help. But there are our details and obviously all our lovely LinkedIn QR codes at the bottom there as well. So my thanks to Kate Kapp. And my thanks to Benedicte Perowne. Thank you so much for joining me on today's webinar. Brilliant advice there.
Thanks, Emma.
Thank you.
And just to flag as well, we're launching a new course. Benedicte and I are launching a new public course, but again, we can come and run stuff in-house for you as well. And this really is looking at the non-financial misconduct. So please do join us. 2 hours virtual on the 1st of July, where we're really helping businesses get ahead and understand what they need to do so they can start their planning in good time for September, because time, as we know, is ticking by. And also we're here, you know, with the ERA, with our rollout support that we're offering. So again, policies, contracts, yes. Strategic support, yes. And obviously, you know, workforce planning. And I just say I'm running courses for managers looking at how we manage through times of legislative change. So particularly around, you know, managing probation, managing terminations, and making sure that your managers are on board with what they need to be doing and when. So thank you so much for joining me today. As I said, any questions or queries, then please do come back. But I look very much forward to seeing you at our next event. Thank you very much indeed. See you all soon. Bye-bye.